John Eastman was ordered by a court to turn over, I think, 8 emails that the court found, based on evidence, fell outside of John Eastman's attorney-client privilege under the crime fraud exception, because it contains evidence of a crime or attempted crime. So that because that privilege didn't work, and he had invoked that privilege to keep those emails, the emails go to the committee. And I would suspect that the Department of Justice will want those emails as well, and so it may request the committee to turn over those emails. Now, what we know so far from John Eastman's email and the factual findings of the court, as the court laid out, is effectively what we knew beforehand, peripherally, that Donald knew at the time of making of these lies and going to court to present these lies, that these were lies, and he attested to it on a piece of document. And it is that proof that shows Donald acknowledging with his signature that he knew what he was saying was a lie. Is state of mind culpability, is corrupt intent, and, as the court put it, to hinder and delay official congressional proceeding, and to defraud. So, I mean, that's Eastman's fake elector plan. So, this is just one piece of the much larger search for evidence to prove, direct evidence to prove, that Donald Trump had the intention of overthrowing the United States government or delaying and hindering official proceedings by way of force. And the statute of seditious conspiracy, 18 U.S.C. 2384, sort of spells that out. And I've talked about it several times. Now, the relevance of the Eastman ruling here is that the January 6th committee will get these 8 emails that have very high probative value, meaning they are very high on the proof scale of what they go to prove in a criminal trial or in a trial. So, and I said that, the Department of Justice may request those documents from the committee. And from the Georgia standpoint, I haven't gone into the Georgia statutes and followed that investigation at all, so I won't comment on the specifics, but it goes to the similar probative value to prove that he pressured Georgia election officials to change the vote, and despite knowing what he was peddling was false. So this is one of the smoking guns. And, many legal experts have said that, there's ample evidence to prove a conspiracy to defraud under 18 U.S.C. 371, and perhaps even rebellion and insurrection under 18 U.S.C. 2383. But I would like to point out the part where the court finds that his actions of delaying and hindering happened in the courts and he did that in bad faith. That court finding is sort of much higher in any sort of evidentiary value than circumstantial evidence excuse me, that he knew. in the sense of other people testifying. His signature on a line attesting to it is about as strong an evidence there can be. And I suspect that we will find more. Maybe not from Eastman, but we will find recordings, testimony from other witnesses, corroborated by other witnesses, is strong testimony, but nothing like a signed document by Donald Trump. And how did he know that what he was peddling was a lie? Because he was told the exact same thing by dozens of people in each other's presence. So that part of corroborative evidence of so many people saying the same exact thing and it being sort of put against the fact that him knowing that in the presence of all those people, because it's been corroborated that they were all there and he was told these things, everybody from Pat Cipollone to Eric Hirschman to Bill Barr to other aides who he asked himself voluntarily about the elections. And still, despite these dialogues, he continued the lies and put his name on the lie. You know, it's building up the case of him having the intent to defraud. My argument is, what is it defrauding? And what did it accomplish? What was his intention? Was to defraud the electoral vote count? What would that accomplish? It would overthrow our government. So and I'm just going by the fake elector scheme here because we're talking about John Eastman, by having the intention and showing this evidence of him having the intention to defraud, he was intending to defraud the United States government by this fake elector scheme and overthrow the government and violate American law and delay, hinder, obstruct proceedings by force or other means. That is also part of the seditious conspiracy statute. And then you add the other element of the seditious conspiracy statute of incitement. And that goes to his speech and his tweets beforehand and the knowledge he had. And we know that from the corroborated testimony that it was not a stolen election, that Mike Pence couldn't do anything other than certify the votes. It was all out there for him. He knew all of it. And he still chose to put his signature on that line. He still chose to obstruct proceedings with court cases in bad faith, knowing the truth that he had lost the election and the election fraud claims were lies. And he went on with those lies in defiance of court, all the courts that he lost in, and the Supreme Court in the Ken Paxton case, sent out the Will Be Wild tweet, went on January 6th, and incited those words in his ad-libbed speech and hurtled his shadow army armed to the teeth and planning an insurrection to the Capitol. So it is building up. And this is another big development in that evidentiary basket, because you can't rely on just one argument. And you'll notice this in the DOJ filings in regard to the special master, that the DOJ presents at least 10 alternate arguments for why the special master review is just out I can't give any sports reference because I don't know sports very well. It's just absurd. Uh, so anyway, so I want to just talk to you about this Eastman thing. This is a development. This is a significant development, and uh, Donald really can't do much at this point. He can start. I mean, if he wants to intervene now to stop those emails, the biggest question will be, where were you all this time that this was going on? Why didn't you intervene before?